For some separated couples raising children together, the pandemic has exacerbated differences in values. Well, now that vaccines have been approved for children 12 and older, what happens if divorced parents disagree on getting their kids vaccinated? For answers on this, joining us this morning is Laura Paris, associate lawyer at Shulman Partners LLP. Laura, thank you for being here today. In cases where parents cannot agree and they go to court, what factors does the court consider?
So for the most part, when you're considering any decision as it relates to a child, you're looking at what is in the child's best interest. And right now, the guidelines that we have to basically rely on when you're talking about the pandemic and safety concerns are those which are provided to us through the government and public health.
Laura, a recent Ontario case involving a 7-year-old and a divorced couple saw the court grant the mom sole parental decision-making power over the child's education, religion, health and well-being, but specifically granted the father the power on deciding on vaccinating. So what went into that particular split? Why give one parent that choice when all the other ones went to the other parent?
So definitely very interesting case and very telling in terms of how the court is going to deal with this vaccination issue as on a go-forward basis. In that particular case, mom was against the COVID-19 vaccine. So the court looked at the factors and looked at basically the history of the case and saw that in most respects, mom made very good decisions for the child, and in that gave her primary decision making over everything. But on that one particular issue, as it related to the vaccine, the court could not stand behind that decision, again, using the public health guidelines as a benchmark, finding that mom's decision not to have the child vaccinated would not be within her best interest.
Most couples going through divorce do not want to head to court. That's a last resort. So what can parents do to avoid heading to court over this issue?
It's a bit of a difficult topic to avoid court on. And the reason being is that it's a very, very polarized issue. It's basically in order to come to any sort of compromise, one person is going to give up on their position. Something that I have recommended to clients who are going through this and who differ in opinions on whether or not to administer the vaccine to their children is perhaps to consider waiting to do the vaccine. A lot of people feel uncomfortable with the fact that this vaccine has gone through really quick testing and has not been formally approved and is being administered under an emergency order. So perhaps we wait until we do get those formal approvals and a bit more of a peace of mind in terms of what the long-term effects of this vaccine is. So that would be something, a sort of compromise that you could consider as parents.
But in the case where Health Canada approves these vaccines on a permanent basis for children 12 and older, is there a scenario where a parent adamantly against vaccinating their child could win their case?
Really, it would have to come down to something specific to the child. If the child has some sort of underlying condition, allergy, something to that effect, where that particular child may be at risk with respect to this vaccine, certainly you could win the case in that regard. You would definitely need to have requisite medical evidence that would demonstrate that this vaccine is not recommended for this particular child.
Laura Paris, thank you for laying that out for us. We appreciate it.
Thanks for having me.